listening to Estate at the Union, estate planning made simple. Here's your host, Brad Wiewel from Texas Trust Law in Austin, Texas.
Hi, this is Brad Wiewel with Texas Trust Law. This is our podcast, The Estate of the Union, and today we're going to have a greatest hits edition. We send out a weekly blog to folks who are on our electronic mailing list, and if you'd like to be on that mailing list, let us know. We're happy to put you on. We do typically 3 or 4, sometimes 5 blog posts at a time. We've got 2 that are the most popular ones, and the first one is this one, that the IRS made a ruling on Grantor Trusts. This is the largest one we've ever had. 17,000 people have read this. That's like crazy because Grantor Trusts are very obscure and not used very often, but we'll talk about that here in a second. And the other one with nearly 10,000 views is the article we're going to talk about here about gifting money or giving money to children. Now, a little more relevant. A lot of people have children, a lot of people have grandchildren. We'll talk about this too. So, are you ready to talk? Yeah, let's talk. All right, we're going to talk about these things first. The Grantor Trust one, this amazingly popular one. Now, Grantor Trusts are out there. If you've got a revocable living trust is a Grantor Trust. This ruling has no effect on revocable living trusts. A Grantor Trust, to give you as succinct a definition as I can, is a trust where when you put the assets into the trust, you don't have to recognize capital gain. You don't have to file a special income tax return. You may not even need a tax ID number. You certainly don't need a tax ID number with revocable living trust. So when I put my assets, my wife, we put our assets in our trust. We don't have to pay capital gains taxes on those. We don't file a special income tax return. Our taxes don't go up. Unfortunately, our taxes don't go down. The IRS looks at a Grantor Trust as an invisible thing. Now, I am actually in the middle of reading The Invisible Man by H.G. Wells, and it was written about 1880, and I've always wanted to read it, and for some reason, I picked it up, and I'm reading it, and it's about a gentleman who, of course, is invisible. But he's still there. You can touch him and feel him, but you can't see him, and that's kind of how a Grantor Trust works. The IRS doesn't care that you have this trust. They can't see it. You can't feel it, but they know it's there. You know it's there. So you just report all the income from the activity of the trust on your 1040, and you get on down the road. So that's the most common use of a Grantor Trust is a revocable living trust. No tax effect either way. But what the article is getting at, and what we do at our office sometimes, is create irrevocable Grantor Trusts. And this is what the IRS ruling is going to be all about. When I create an irrevocable Grantor Trust, so let's say we're creating one for the Smiths, and the Smiths want to make gifts to their children. And they want to make gifts to their children because they have a large estate, and by shifting assets out of their estate into the children's estates, the future appreciation on the assets, once they're in the kids' names, not their name, is out of their estate for estate tax purposes. And when they die, when Mr. and Mrs. Smith die, the assets they've given away to the kids, again, the future growth on those assets is not going to be in their estate. They won't be taxed on that. It's a pretty smart move. But what's this Grantor Trust do? What is that? How does that affect things? Well, the way Grantor Trust works in that setting is we would help Mr. and Mrs. Smith set up this trust. They're going to put their assets in it, and then they're going to gift assets to their children via this trust, and the trust is going to be for Jimmy and Johnny and Judy. We'll probably set up 3 Grantor Trusts so that Jimmy, Johnny, and Judy's money is in this trust for them. It's divorce protected for them. It's lawsuit protected for them. It's bankruptcy protected for them. If they're adults, they get to be their own trustee, but Mr. and Mrs. Smith, it's a Grantor Trust as to them, they're going to continue to pay the income taxes on the income earned inside their children's trust. Now, that's got to be crazy, right? I mean, why would I put the money in a trust for my kids? The investments are generating income, and somebody's got to pay the taxes. Why would I pay them? And I would want to pay them because by paying the taxes on my kids' trust, this Grantor Trust I've set up for my kids, because the income tax is going to come back to me. Every time I write a check to the IRS for the taxes on their trust, I'm really making an additional gift to them. And I can only give so much to them, okay? And if I've gifted the money into these trusts, I've had to use some of my exemption, my exclusion. Currently, the amount I can give to anybody tax-free, I can do the $17,000 a year deal. If I give somebody over $17,000, I cut into my lifetime estate tax exemption. And my lifetime estate tax exemption this year is just shy of $13 million. And I got my $13 million, and I got Cindy's $13 million, and we can gift our kids $13 million each, $26 million. And not have to pay estate taxes, not have to pay gift taxes, that's out. But once it is out, the income that we're going to be paying the income taxes on for our kids grows is letting those trusts for our children grow income tax free. So the money that they're earning inside that is income tax free. We're paying the income taxes. We're making additional gifts to the kids. And it's a pretty smart strategy for a lot of people. They shift the assets out. They continue to pay the income taxes on those trusts, but they're going to be paying the income taxes on it anyway. They kept it, they pay the income taxes. We put it over there, it's growing tax-free, it's out of our estate, and it's a smart move. So great. Two things. What if I don't want to pay those income taxes anymore? And we have had clients who come to us and say, Brad, Rob, Zach, I'm kind of tapped out. I really can't afford to pay the income taxes on my children's trusts anymore. Can I get out of it? And the answer is, yeah, you can. You can turn it on, you can turn it off. It's called toggling. And we can toggle it off, and when you toggle it off, then the kids now will pay the income taxes on the money that's in the trust that you set up for them, and you're relieved of your responsibility to pay the income taxes on those trusts, because now it's not a grantor trust. Now it's, of all things, called a non-grantor trust. They pay the taxes and get on down the road, which, you know, kind of does make sense, right? Because they got the money now, and you don't want to have to dole it out every year to the IRS. What's interesting about this IRS ruling that was such a big hit on our blog post has to do with step up in basis on the assets that you're given to the kids. And so the way that basis works is what you buy it for is your basis. So if I bought Apple stock for $100 a share, and it goes up to $1,100. So I've got $1,000 profit. I bought it for $100. It's now worth $1,100. The $1,000 profit, if I sell the Apple stock, is a capital gain, and I pay capital gains taxes on that. My stock, I bought it, I sold it, I pay capital gains taxes, which can run currently about 23.8% of the value of the gain. So good night. I write a check to the IRS for $238 of the $1,000 I made off the sale. That's, you know, some money. I don't like that, but that's how it goes. When somebody dies, and this is a generalization because there are going to be some exceptions, which we're not going to go into today. As a general rule, when somebody dies and they leave it to their heir, the heir gets a new basis in the assets, the non-retirement account assets typically, of the deceased. So if I die and I leave it all to Cindy, the Apple stock that I bought for $100 that's now worth $1,100, she gets a new basis in the stock of $1,100. She can sell it the day after my funeral and not pay any capital gains taxes because she just got a new basis based on my death, which is great. It just kind of wipes out the debt and wipes out the taxes. Again, it's something that as estate planning lawyers, we have to also take into account if we're going to make these gifts, because when you make a gift to someone, back to these grantor trusts, Mr. and Mrs. Smith are going to make a gift of assets they have to their kids via these grantor trusts. When I get a gift, I get the donor's basis. So if the Apple stock that Mr. and Mrs. Smith are going to put into the trust for the kids, if they bought it for $100 a share and it's now worth $1,100 a share, when the kids get that stock in their respective trust, their basis is $100, not $1,100. Because again, if I make a gift, the donor, their basis transfers to the donee. You want to know what they're called? And so the kids now have the same basis mom and dad did. Well, all right. What about this tax? What about this the step up when I die if the assets are in a grantor trust? Well, let's go back and refresh ourselves on one more thing. Remember that when I put the assets in the grantor trust, I don't recognize capital gains because it's me. It's like I took my name off a Merrill Lynch account and put it into an Edward Jones account. I take it out of my name, Cindy's name, Mr. and Mrs. Smith's names, and put in their kids' names. Because the trust that we're putting the assets into a grantor trust, Mr. and Mrs. Smith do not recognize capital gain. It's pretty cool. Shift it to the kids. It's out of their estate for estate tax purposes. The kids get mom and dad's basis. When mom and dad die, and this is kind of the gist of this ruling, the kids don't get a step up in basis. Okay? The kids' basis is the same as when mom and dad gave them the stock. So they don't get a new basis. And I had a CPA this week ask me, "What do you think that's fair?" And I will say this as clearly as I can. You know, the IRS is not my friend, and they're not your friend, all right? But they do have a job to do, and it's a vital job, and God bless them for doing it because I don't want to do it. It does seem to me, frankly, that if I'm going to play this little game where I get to take assets out of my estate, put them in somebody else's estate with a grantor trust, I don't have to recognize capital gain when I do that. Well, you know, when the kids get it after I'm dead, it's already in their trust, they don't get a step up in basis. They get the same basis. It's, you know, along the way, somebody's going to pay the taxes on this, and that's what the IRS is saying. It said, look, you know, you got this good deal going up front, Mr. and Mrs. Smith. You're giving it to your kids. You're not recognizing gain, but when you die, they're not going to be able to step it up. Their basis is to stay at the $100 an Apple share that you originally gave them. So that's kind of the gist of this ruling. Again, we use grantor trusts when we do, we call that advanced planning. Rob Hugo's here is our Director of Wealth Preservation and Protection. That's our new name for our advanced planning section. Wealth Preservation and Protection. And the protection is from lawsuits, but also the IRS. And he does a good job. If you're interested in looking at a grantor trust for your family, please let us know, and we'll set you up with a conversation with Rob, who can walk you through how it might work in your particular situation. So, 17,000 people thought that was a very good. It is a very good article. It's a little obtuse. Hopefully, this has helped explain it. All right. The greatest hits continue. The second, almost 10,000 views, is only leave my money to minor children in a trust. All right, now, this is probably the second biggest mistake people make in estate planning. The biggest mistake people make in estate planning is not to do any planning or to do inadequate planning with a crap software program with a lawyer who doesn't know what they're doing. That's the biggest mistake because you either don't have anything or you have something that's defective, which is why you should see us, because the stuff we do won't be defective. We know what we're doing, and we'll do it right. The second biggest mistake, though, is leaving money directly to minor children. And this happens all the time. It happens all the time in two separate settings. One is mom, dad, whomever, grandma and grandpa, will put the minor child down as a named beneficiary on an IRA, a 401k, a 403b, or a life insurance policy, okay? Well, I want them to get the money, Brad. That's the best use. They're the people I love. I mean, if I'm married, I'll make my spouse the primary. I'll make my kids the contingent. What's wrong with that? The second big issue is when people do a will or a trust, which we won't do here, and they name the minor child as a direct beneficiary. We won't do that. We'll make sure it goes in a trust. Okay. So the problem with mom, dad, grandma, grandpa leaving money directly to a child in a life insurance policy, an IRA, or a will is that that child can't own property. They can't own property because they're a minor, and minors are legally unable to own money in their own name, property in their own name, because they don't have the maturity or the bandwidth to manage it. I don't know what a 15-year-old would do with $100,000 given to them in a life insurance policy. It would be taken by somebody else who will abuse the whole thing, and that's the risk, and that's what the law wants to prevent. If they're over 18 in Texas, yes, you can name them, but would you? I mean, I've got 3 kids. I myself was once 18. It would not have been a good idea to leave me $100,000, let alone $500,000 or $1 million or 50 cents, probably. And so what happens when a minor receives money and they're under 18, it has to go, unless there's planning, and I'll get to the planning aspect here in a second, which is why you only leave minors their money in a trust. If they get it outright, it's almost always going to have to go and have a guardianship established for the child. And the guardianship is going to be called the guardianship of the estate. And you're going to have to have a lawyer help get this set up. And the lawyer is going to charge money. And then the court is going to appoint a guardian. Now, who's the guardian going to be? Well, I mean, gosh, maybe it was my spouse who died, the kids were on the beneficiary form. You would think the mother, the surviving parent would be able to do it. Probably would, but not necessarily. Whoever the guardian is going to have to post a bond, and if they don't have good credit, they can't get a bond. The judge is not going to say, you seem like a real fine person. Here's $500,000, manage it for Judy and Johnny, and when they're 18, be sure to give it to, oh, okay, sure, you bet. Well, but year 1 or 2, you know, I've got some problems, I need some money, I could use a new car, I could take a vacation, blah, blah, blah. So the court requires a bond to make sure that the guardian does their job right. And if the guardian does their job wrong, the bond money goes to the estate of the child. The guardian gets sued, and the guardian may go to jail because they have breached their fiduciary duty. So not a good idea. Every year, by the way, the guardian has to report to the court what the investments are and how they're being managed and what's being spent. And every year, you're going to have to hire a lawyer to do that too. So it's a big, huge hassle. And when Johnny or Judy turn 18, they get all the money. Have a good day again. Try not to spend it all in one place, sonny or honey. Okay, I sure won't. You bet. And the first thing they do, of course, is they go to the car dealer, get a truck, get a car, blow it, and away it goes. And it's horrible. There are other ways to leave money to a minor. A common way, which we don't like this either, by the way, is to set up uniform transfers to minors account, a UTMA account. And you can put money into a UTMA account, and you can name who the custodian is. Now, if it's my money and I'm putting it in for a grandchild, I get to be the custodian if I want to. I can make my child, the parent of my granddaughter or grandson, the custodian. Great, well and good. It doesn't have to go through court. They get the money. They manage it for the child. When the child turns 21, the money has to come out and go to the child. You can't keep it in this account after the child is 21. Well, I mentioned my maturity level at 18. My maturity level at 21 was, half an inch greater than it was when I was 18. Maybe a quarter of an inch, maybe 3/4. Heck, a given day. But I was certainly not mature enough to manage the kind of money that we're talking about in any of these situations, but the money's going to have to come out. I know of a situation where the young person who was just turned 21 was supposed to get the money, and guess what they had? A heroin addiction. And if the money was going to come out to that child, they were going to get it, they were going to spend it on heroin and probably kill themselves. Fortunately, through some very creative legal planning, we avoided that, but the child had to cooperate and did, but didn't have to. They didn't have to. Here's all the money. Shoot it up your arm. We'll plan your funeral and see you later. So it's a horrible result with these UTMA accounts. And maybe again, the child's a good kid, and here's the money. It's $10,000, $20,000, not enough to ruin them. That might be okay. But the best way, the only way to leave money to a minor is in a trust. And what you can do when you leave it to a trust, and we build these trusts in our wills, and we build these trusts in our revocable living trusts. What mom and dad can do with their IRA, grandma and grandpa can do this, with their life insurance, is they make the trust for the grandchild or their child the beneficiary. Either the primary beneficiary if they're single, or the contingent beneficiary, maybe usually the spouse is going to be primary. They can not name the child as the beneficiary, but name the trust we've created for the child in their will or the revocable living trust as the beneficiary. When the money comes in, it goes to the trustee. The child's not going to be the trustee. The people who crafted the will or the revocable living trust have told us who they want to be the trustee. And the trustee gets the money. The trustee is a mature person, and the trustee has a legal obligation, a fiduciary obligation, the highest level of responsibility, legal responsibility you can have in the law is a fiduciary responsibility, and the fiduciary responsibility is to manage it for the child and distribute it for the child's need, typically for their health, education, and maintenance, until the child reaches the age that you, the person who created the will or the revocable living trust, believes at this age the child will be mature enough, and then Mr. Trustee, Miss Trustee, write him a check for the balance and get him on down the road. Sometimes we leave it in a lifetime trust, and we leave it in a lifetime trust because the mom and dad want to divorce protect it, laws to protect it, bankruptcy protect it for their child. And then in that situation, we pick the same age, but then we say that's the age the child gets to be their own trustee. So they get to decide how the money's spent, how the money's invested. They just won't lose it to a third party. We call those trusts a family wealth protection trust. So keeping it in a trust allows mom and dad, grandma and grandpa, whomever, to make sure the money goes to the benefit of their minor child. The money is available for their minor child for education, for health expenses, for maintenance. I mean, good night. Pretty much spend it whatever the trustee thinks is wise. But when the child then reaches a more lofty age, more than 18, more than 21, usually it's 30 in our office, but it's sometimes less and it's sometimes more. Then when they reach that age, then they get control of it, and we get them on down the road. So let's go back to what I said at the very beginning of this section. The worst thing you can do in estate planning is not having a plan or having a crappy plan done by a software program or a lawyer friend who didn't know what they were doing. The second worst thing to do is to name a minor as a beneficiary of that will, of that trust, of an IRA, of a life insurance policy, and not have that run through a trust, because it's going to be a lot of legal expenses. It's going to be a mess. It's going to be court supervised. You're going to get a law at 18. We don't want that. So contact us and we can help you. We have a complimentary consultation. We have 4 offices here: Georgetown, Horseshoe Bay, Wimberley, San Antonio. We'll see you, and we'll see you at complimentary the first time. That means free. So free is always a good word. We will see you for free the first time. And we'll go through what your options are, and we're happy to help explain all this in a little more depth, and particularly focus on your situation, not somebody else's. So, greatest hits. We'll come back with more later. We've got some good guests coming up on the State of the Union. We got some folks from Hospice Austin coming in. We have a judge coming in. So be alert to future podcasts, and we'll keep the good news coming. Thanks again, and we appreciate you.